And oops, I'm sorry. And so yes, we're going to jump right in. And after the presentation, we'll be sending out a copy of the slides and also several written materials that are helpful on this topic. The Office of the Inspector General, the OIG, has over the years put forth a lot of compliance guidance, and some of it has focused specifically on these types of discount, waiver, free service or item considerations. So luckily there are helpful resources that you can use and refer to in your practice. So with the written materials, you'll get a copy of the slides and then also several different OIG resources that you can utilize going forward. Just a few preliminaries, as always, with these presentations. All of our webinars are recorded and now are up on a YouTube channel that can be accessed through our healthcare group blog, which is hhhealthlawblog.com. If you have any questions, feel free to submit them on the chat line in the WebEx, or definitely you can email me offline. My email address is there. And if you have any technical problems during the program, please reach out to Luke Kelly. But again, this will be recorded and put up on the blog and YouTube channel, so if you want to refer to it later, it'll be there. This webinar will give an overview of these legal issues and considerations, but please always keep in mind with any of our topics that the applicable law to your practice type and location is likely to be slightly different from others who may be listening today. So a different analysis on many of these issues will be dependent on the state you're located in, the type of facility or provider that you are or that you work with, your governing documents and contracts, especially in this context, your private payer, your third-party payer contracts may have things that will separately weigh into these topics. Much of what we're going to cover today is in relation to federal law and federal health care programs, and many private payers follow similar requirements and rules, but often their contracts will have slightly different or slightly unique requirements on these topics to that payer. This program does not establish attorney-client privilege and does not constitute the giving of legal advice. So with those out of the way, let's jump in. So some of the common dilemmas that we're going to talk about today include giving either free or discounted items or services to patients, waiving copays, writing off debt, prompt pay discounts, free screenings or tests, free transportation, gifts or perks to providers, and then professional courtesies. And walking through each of these topically, I'm also going to wrap up with some steps and kind of a compliance checkup that you can potentially run through or keep in mind when you're entering into new relationships to watch out for or at least consider some of these different dilemmas and how they may come up in your relationships and contract practices. And you'll see with most of these topics, there are a few key laws that I'm going to keep mentioning, and they relate similarly on many of the different types of copay, discount, and waiver considerations, but also are slightly different and have different either exceptions or safe harbors, which may apply in one circumstance but not others. So you'll hear me talk about the Anti-Kickback Statute, and that's the federal Anti-Kickback Statute, the Ethics and Patient Referrals, or Physician Referrals Act, and that's commonly referred to as the Stark Law, also a federal law, the Civil Monetary Penalties Law, and then I'll talk about state fraud and abuse laws or where those are applicable in terms of needing consideration or being part of your specific analysis. However, I'm not going to describe any state laws specifically, given that I think we have participants from many states on the line, and each state may approach some of these topics slightly differently. And just to give a general overview of these laws, to the extent you would like further information on any of the federal laws, some of our past webinars have gone in much greater depth to each of these laws specifically, but I'm just going to run through here what they are and, most importantly, why they matter in looking at the topics we're going to cover. So the federal Anti-Kickback Statute provides that you cannot knowingly and willfully offer, pay, solicit, or receive remuneration to induce referrals for items or services covered by a federal health care program unless a regulatory exception or safe harbor applies. And those are found in the regulations in the CFR section. The Anti-Kickback Statute is a very broad statute, and it can apply to any transaction between referral sources or program beneficiaries. It also applies on both sides of the transaction, so it can be applicable to the person both offering remuneration and receiving remuneration. And the Anti-Kickback Statute applies to any type of entity or person, so you do not need to be a healthcare provider to be in the reach of the Anti-Kickback Statute. You just need to be involved in the healthcare service chain of delivery or either providing or receiving healthcare, and it could apply to any relationship in that status. The Anti-Kickback Statute is a criminal statute, and because of that, it's intent-based, which means there must be some intent to induce referrals with the remuneration involved. However, and very significantly, if even one purpose of a transaction is to induce referrals that are covered by federal programs, then the Anti-Kickback Statute is implicated. So there may be many non-referral related reasons and purposes for a relationship, but the test that's been set forth by federal court decisions has been that just one purpose needs to relate to referrals. Violations of the Anti-Kickback Statute carry hefty penalties potentially. It would be a felony level crime to have violated the Anti-Kickback Statute. Can carry with it up to a $25,000 fine and up to 5 years in prison. Can also subject an individual or entity to up to a $50,000 administrative penalty, and very significantly could result in exclusion from Medicare and Medicaid and federal health care programs, which can definitely be devastating for health care providers of many types. The Anti-Kickback Statute violations are also violations of the False Claims Act. And so in addition to the penalties just under the Anti-Kickback Statute, the violations also can lead to additional fines, up to $11,000 per claim, and then multiple multipliers on top of those amounts of damages. And I mentioned at the end, key TAM lawsuits, also known as whistleblower lawsuits. The way that oftentimes anti-kickback violations, including violations that may relate to some of the things we're going to talk about free services or practices of discounting and providing items which are intended to induce referrals, those often work their way to the government for investigation and potentially prosecution through whistleblowers. So definitely, want to be mindful that these actions don't always start with the government just coming and knocking on a door. Someone in an organization or who's aware of the activities of an organization can actually bring information to the government, and then a key TAM lawsuit can proceed from there if the investigation proves that it's warranted. The next law is the Stark Law, and again, that's the Ethics and Patient Referrals Act is the full name. This law is, again, related to federal healthcare programs, Medicare and Medicaid. But the Stark Law only relates to referrals by physicians. So it prohibits if a physician or a physician's family member has a financial relationship with an entity, the physician cannot refer patients to that entity for designated health services payable by Medicare and can't bill Medicare for those services improperly referred. And similar to the Anti-Kickback Statute safe harbors, the Stark Law has regulatory exceptions that allow a variety of relationships if they're structured in the manner set forth in those regulations. So unlike the Anti-Kickback Statute, this relates to physicians referring and sending patients, but and so not to providers other than physicians, but it also is a strict liability statute, so in some respects is less broad than the Anti-Kickback Statute, but also is potentially a higher level of liability because no intent of a violation needs to be proven. So even if you have good faith intent to comply or no intent to have something be inducing referrals, if there is not an exception met and a physician with a financial relationship with an entity refers DHS, it would be a violation of the Stark Law. So very, very important to make sure that you're compliant and considering compliance with the Stark Law when physician referrals are implicated. And I won't read through all of these, but the types of services that are implicated as DHS in the Stark Law include this list of services, and there's also a separate list each year of specific CPT codes put out that are DHS, so these categories of services and then additional codes that are listed each year. Again, just highlighting why the compliance with the Stark Law is important and non-compliance can be very, very devastating, is that the penalties include that no payment for DHS during a period of disallowance, required repayment for improper referrals received, and the repayment must be made within 60 days. So you're on the clock as soon as you determine that there's been amounts received for improper referrals. You can have fines up to $15,000 per claim submitted and up to $100,000 per improper scheme. Also, like the Anti-Kickback Statute, Stark Law violations may be False Claims Act violations. So again, that can lead to where you have significant amounts of penalties per claim submitted, multiplier of damages, whistleblower key tam lawsuit potential, and importantly, also could result in exclusion from federal health care programs. And finally, is the federal law that I'm going to mention a few times as well throughout the presentation, the Civil Monetary Penalties Law, also federal law, and it prohibits various actions including submitting claims if they're provided by an excluded provider, inducements, and these next couple are the ones that are really specific to what we're going to be talking about today, inducements to beneficiaries of federal programs, so Medicare and Medicaid beneficiaries, to receive reimbursable services, and inducements to limit services by hospitals, which sometimes are most topically is called gain sharing, and then also failing to repay amounts when due. Violations of the Civil Monetary Penalties Law can range from $10,000 to $50,000 in fines, can have up to treble damages, and also can lead to exclusion from federal health care programs. And not to go through it all again, but again, civil monetary penalties violations can also be Federal False Claims Act violations. So you'll see as we're going through this that these laws are all independent in that they may be separate violations if conduct does not comply with each of these laws. That means that the penalties imposed may be very significant because you could in some instances have 3 separate laws come into play and violations of 3 separate laws come into play, and then ultimately violations of each of those laws can also be False Claim Act violations. So the amounts of penalties, the potential for exclusion from federal health care programs, and really devastation to a healthcare practice can be great. So I don't want to underplay the significance of understanding each of these laws and how they each figure into what we're going to be discussing. And then I'm not going to, again, not to talk about references to specific state laws, but many states or most states have they're a version of an anti-kickback statute that prohibits paying for referrals or providing some sort of inducement for referrals. States often have many Stark laws or provider self-referral laws. Those, depending on the state, may be specific only to certain types of providers or have exceptions for certain types of providers. Depending on the state, they may or may not also tie to specific types of compensation or payment. So may include only, in some instances or for some purposes, government provided benefits, may also reach all types of healthcare reimbursement. So from federal or state payers down to cash pay patients. So definitely want to keep in mind what your state provides on that front. Fee splitting statutes, those statutes are often found in the statutes that govern the licensing and professional conduct of various types of healthcare providers. And then laws prohibiting paying cappers, providing rebates. Oftentimes, states also will have, sometimes in their healthcare or healthcare financial type statutes, or also in their consumer protection statutes, things that again prohibit certain types of payment arrangements that would have patients directed in various ways for healthcare services and remuneration or some sort of compensation tied to that direction. So now getting into the different types of arrangements that may be at issue with discounts, free services, et cetera. The first I'm going to talk about is patients, providing patients free or discounted items or services. And the way that these relationships or these situations may arise, in common instances you might see them, would be advertising or marketing campaigns that include free or discounted items, free services, especially when those are tied to receiving or somehow getting into a status of getting other services that would be paid by government payers, even if the free item is not something that's covered by a government payer. Providing gift cards or other rewards for referrals, or providing thank you gifts. So the issue and why this comes into play under the federal laws that we're considering is that free or discounted items or services, which would by nature then be less than the fair market value of those services, is that these are a form of remuneration, and the concern is that they may induce the patient to receive services or pick pick a provider based on that inducement or remuneration, or seek services based on the free or discounted items or services. Because of that concern, free or discounted items or services may violate or at least warrant consideration for compliance under Anti-Kickback Statute, again, keeping in mind that if one purpose of the discount or free promotion or structure is to induce referrals for items or services payable by a federal healthcare program, that can be problematic under the Anti-Kickback Statute. The civil monetary penalties law, if the promotion or discount program would be likely to induce a beneficiary to receive items or services payable under government programs. The Stark law, if this was offered to referring physicians or their family members, and also the state laws that either may be similar to those federal laws or may have separate state prohibitions on giving rebates or discounts or free or discounted items. There are some exceptions and carve-outs under the federal laws where these types of arrangements have been either given explicit approval, or there are considerations that would lend themselves to a potentially compliant relationship, though often you're still going to want to analyze each of your proposed programs or campaigns on a case-by-case basis to ensure that it's compliantly structured. So the first way, or one of the first carve-outs, is if the remuneration is not likely to influence the beneficiary to order or receive items or services payable by a state healthcare program. So that's going to be a fact-specific consideration, but I think typically the less or not having a tie to federal or services that are reimbursable by federal or state healthcare programs obviously is going to reduce that significantly. The more that any remuneration is discussed in the same promotion or campaign or anything as, you know, even in mentioning anything that's also a federal or state healthcare reimbursable service, the more potential concern or at least more caution you want to take in how you're presenting the free or discounted item or service. Another indication is where these types of free or discounts, free services or discounted services may work is if the item or service is of low value. So if each item is less than $10 and the aggregate is less than $50 per patient per year. So if you're relying on this carve-out, definitely keep in mind that you want to look at your whole year, and if you're running a campaign where you're giving promotional items or something that is of low value, just also want to ensure that you're not doing that multiple times in every month or something that's likely to be able to exceed the per patient per year total. And this is in part of one of the OIG bulletins that will be sent around as part of the materials, which was specific to gifts and inducements to program beneficiaries. Under the civil monetary penalties law, their definition, or the definition in that law of remuneration, actually also has a few helpful carve-outs. So remuneration just does not even include, it excludes, and so it is not part of that definition if you're talking about incentives to promote delivery of preventative care, payments meaning an anti-kickback safe harbor, remuneration promoting access to care, and posing a low risk of harm to patients in the federal healthcare programs, retailer coupons, rebates, or rewards, and certain other situations. The others are much more limited and nuanced, but would be worthwhile to look at those if you are considering free or discounted items or services. And you may then offer items to government beneficiaries under the civil monetary penalties law if it does not fall within that definition of remuneration. So, and definitely also keep in mind that with free or discounted items, you want to, this is a helpful analysis or bullet point to, I think, walk through with each item or service, that you've made a good faith determination that either the beneficiary has a financial need or reasonable collection efforts have failed, that they were not offered as part of any advertisement or solicitation, not tied to receipt of other federal program business, and there's the reasonable connection between the item or service and medical care of the beneficiary. So this is another way that provision of services would not fall under that definition of remuneration. So likely in any situation, not all of these exceptions are going to apply. But if you're considering either a promotion that would be a free item or service, an individual situation where you're not actually advertising but giving in a certain case or a certain instance free or discounted items or services, these different exceptions and carve-outs as set forth in the federal regulations and OIG bulletins may be helpful to match up with what you're planning to do and give you some assurance that you're doing so in a compliant manner. And the couple of there's an anti-kickback safe harbor specific to discounts. And so that's another way that you would meet both Anti-Kickback Statute and the civil monetary penalties law, is if it was a compliant discount arrangement. And then finally, if an item or service promotes access to care and poses low risk of harm to patients or the federal healthcare programs. So, and this is an example in OIG advisory opinion, where a nonprofit entity was providing transportation, lodging, and meal assistance to patients, and some of the things that the OIG considered and ultimately found that that relationship was not likely to be abusive or cause harm to the federal healthcare programs, was that it was not advertised in advance, the costs were not claimed on a cost report, and it was a public benefit offered through this program. So even when the OIG has looked at these circumstances in advisory opinions, definitely are looking at the facts and individual circumstances of the relationships involved. So if there's an independent entity that's also providing free or discounted items to beneficiaries, that type of arrangement and provision is not prohibited in the Divestible Monetary Penalties law, and providers may be able to fund those items or services that are then provided by the third party. But again, keep in mind that you'd want to make sure that the independent entity is the one making the determination of need, and the beneficiary receiving that remuneration, whatever the item or service may be, is not dependent or tied in any way to the beneficiary of that remuneration using a specific provider. So there really should be no tie back to, you know, provider A is funding a nonprofit or a charity giving out a certain type of item, but then there's any tie to the patient being sent back to that provider or having their use of that provider dependent on them receiving that item or service. I'd mentioned a couple slides back that certain types of preventative care and incentives that promote preventative care are not under remuneration. These are a few examples of what are included in the preventative care that's not found to be remuneration. Going into the next, so it's not just the provision of a free item or service or a discounted item or service, may also come into play where you have instances where you're considering waiving or discounting copays or deductibles. And this is the reason from the federal perspective that this is an issue and something to consider is that the providers in what they are ultimately getting from Medicare usually is set in relation to their usual and customary or customary and actual charges. So where a provider is actually then waiving copays and deductibles on a routine basis is not accurately stating potentially, or the government's position is that it's not accurately stating then what its actual charges are if it actually is not charging or would not be collecting the amounts that it's reporting. So that's one concern. The other is that, you know, with the thought that patients, if patients are paying a portion of their care, they will take a more mindful approach to what they're receiving and how those services are delivered, and also just trying to ensure that the federal health care programs are not paying more than it should, or more than they should for healthcare services delivered. And again, you'll see that the reference down below, this will be one that's sent around. The OIG did a specific fraud alert on waiver of copayments and deductibles, so it's something definitely that the OIG has looked at and has considered where the concerns are and how certain compliant relationships can continue. This is also important in the context of private payers or private third-party payers. Again, this would be specific to your contracts with each payer, but oftentimes there are specific requirements that you may not waive or discount copays or deductibles, or if you are able to do so, must comply with the framework set forth by that specific payer. Similar to the previous item, why this matters in terms of our consideration today is that waiving or discounting copays or deductibles could equal remuneration, and then the concern again is that that may induce the patient to receive services based on receipt of that remuneration. Again, all of that then may violate Anti-Kickback Statute if even one purpose is to induce referrals, civil monetary penalties law if it's inducing beneficiaries to receive federal health care items or services, the Stark law if you have physician or physician family members involved, and then your private insurance contracts. These are some situations that I would definitely highlight as red flags and things just to be very aware of and consider and vet fully if you are planning to go down and use any of these lines. If you're advertising that any services are provided with no copay or deductible, especially making statements like Medicare accepted as payment in full, no out-of-pocket expenses, or insurance-only billing, I would caution you on using any of those phrases until you've definitely ensured that that's going to be a compliant practice to then do so. And one thing on sort of the other side of this is advertising in such a way, one, could get you in trouble if you then aren't compliant in how you're collecting copays and deductibles. But if you don't comply with your advertising, you could also face action from typically state agencies, state attorney general's offices, or state enforcement officials for business practices that are non-compliant with state law for improper advertising. So anything where you're doing advertising in relation to how you're going to be treating copays or deductibles, I would just say caution and proceed after you've done an analysis of how you're going to be presenting that advertising. And also, another situation to definitely consider or give pause before you proceed would be routinely using financial hardship forms, and routinely meaning where you don't use those forms or that analysis where there's been first a good faith attempt to collect amounts due, and also a determination of financial need. So it should definitely not be something that's handed out to every patient that comes to the door, and really should just be used in accordance with the procedure or policy that you have in place as to when a financial hardship situation will have or warrant consideration in your practice or organization, and then upon such a determination, how you proceed in determining if there is a financial hardship, and then working with the individual involved on a potential discount or waiver. And then finally, collection of copays only if the patient has Medigap coverage. So again, those are all in the OIG fraud alert, but situations that would just caution you highly before you proceed on any of those fronts. So you may, and again, this is going to some of the federal regulations related to the Anti-Kickback Statute and also an OIG advisory opinion, you may waive or discount government copays or deductibles if such waiver or discount is not offered as part of an advertisement or solicitation, you do not routinely waive copays or deductibles, and the action is taken after you've made that good faith determination that there's a financial need or have been unable to collect after reasonable collection efforts. So really, I think these bullets alone are a great basis for an initial step on a financial hardship, or a piece of your financial hardship policy that gets to copay and deductible waiver or discount. And the things then in practice that will be helpful to document if ever audited or questioned about your copay and deductible waiver or discount practices would be to document things such as the local cost of living, patient's income, assets and expenses, family size, the scope and extent of bills, all the things that and I would say beyond that, anything that on your business side, the information that you want to determine if there is a financial need, document that so that you can show really that there was that process, there was that determination, and that you were actively engaged in doing this on a case-by-case basis, not just something that was a routine procedure for waiver or discount. You may also waive discount or waiver discount copays if they satisfy an anti-kickback safe harbor. For hospital inpatient stays, there are specific anti-kickback statute provisions that are related to waiver based on the length of stay, how those are billed, and especially when you're talking about the way that those costs are then reported. So if you're a hospital provider, certainly look at your inpatient waiver practices. And then federally qualified health centers or other federal facilities also have specific ability to waive or discount government copays. But with all that said, those were the anti-kickback statute ability to waive or discount copays. But keep in mind, even if it would comply with the anti-kickback statute, you also want to make sure that you're not waiving or discounting a copay or deductible that is to a physician or a physician family member, or if so, you need to separately analyze under the Stark Law. If it's to a referral source, that would warrant separate consideration under the anti-kickback statute to make sure that no part of the waiver or discount arrangement is to induce referrals, unless it fits within a safe harbor to the anti-kickback statute for that relationship, the referral source portion of the relationship. And then finally, if you're dealing with private pay patients, you want to check your individual payer contracts or your state law fraud and abuse laws to ensure that even something that might work on the federal front and analysis under the anti-kickback statute also works in your private pay context. Going now further into the billing and collection process, if you get to the place where you provided services and now a patient has debt or bills and you're considering writing off debt, again, could be a concern because it could be viewed as remuneration and therefore could induce patients to receive future services. That can violate anti-kickback statute, civil monetary penalties law, Stark law, and state law, all potentially, depending on the circumstances involved. Big key in this one is to really document why you're writing off the debt or the bill. So want to show and document that your purpose here is for your business purposes, the background on the individual situation you're considering, not that there is an intent to generate referrals by the write-off process. So some circumstances that could arise and things you just want to document definitely in your records as why the debt was written off would be if this was resolution of a legitimate dispute or settlement of a claim with a patient. If you've made unsuccessful attempts to collect, definitely detail your process, how long that goes on, and be consistent. I would say, don't have, certain patients where you're unsuccessful on one attempt and then write them off, but others you continue to try to collect for months and months or years. Have a policy and a process in place and document that you've complied with your process. Financial need, and then other situations that may arise. So there's definitely going to be an untold amount of situations that could arise where writing off debt might be the correct business practice and the correct determination after your practice or organization has considered the individual circumstances involved. Just document that and show why this isn't something that you routinely do, but why each individual situation has been analyzed before there was a write-off. So again, similar to the earlier write-off of debt, you have under the Anti-Kickback Statute separate exceptions and safe harbors for hospitals and federally qualified health centers. And also with civil monetary penalties law, these are again a few bullets that you likely would consider in determining if that beneficiary's bills could be waived, discounted, or written off. So don't want to have it definitely tied to any provision of services, for future services. Want to have done that good faith determination that there is a financial need, or you've made reasonable collection efforts. And this is in the OIG bulletin. The OIG suggested that hospitals and likely other providers, it would also be a very good factor to be able to support if you had an inquiry by the OIG, would be to have a set of financial guidelines that give objective criteria for what constitutes financial need. Make that determination of financial need an ongoing or a recurring process. So don't have that happen once and then 2 years later necessarily go with the original determination. Continue to obtain information from the patient, or at least request information, show that you're trying to actively revisit and continue to determine financial need. And then just can't highlight enough, document that you have these processes, and document that then you're complying with the processes that your organization has implemented. We'll say as a general note, if an entire bill is written off, it's going to be less of a compliance risk than writing off copays and deductibles, because if there is no third-party bills because an entire bill is written off, then a third-party payer likely will not care. But if you still are trying to bill the third party, whether that's a private payer or a federal health care program, but you're not doing that component of collecting the amount of a copay or deductible or piece that should be coming from the patient, that's where you have just a higher or a heightened level, I would say, of potential concern in Anti-Kickback Statute, civil monetary penalties law, and those provisions that may be within your private pay insurance contracts. And finally, again, if a patient that you're considering writing off debt or writing off a bill is a physician or a family member of a physician, beware of Stark law compliance, and know that you'd have to separately have a Stark exception that would apply to the relationship. Another means of discount that providers may utilize or want to utilize is prompt pay discounts. Again, because you're giving a discount, could be viewed as remuneration, and that then there's a concern that could induce patients to receive future services and can violate all of our federal laws that we've talked about, could violate state laws and payer contracts. In this case, usually the language in payer contracts that are of concern with prompt pay discounts are that you are only obtaining from the insurer or third-party payer what your usual and customary charges are. So prompt pay discounts across, if you implement those widely and without consideration of compliance concerns, could effectively reduce what a provider's usual charges are for a specific item or service, and thereby limit what you can actually bill to a third-party payer under the terms of your contract. So OIG has approved prompt pay discounts in a few different scenarios and with a few different considerations involved. Those have included if the discount relates to avoided collection costs. So again, want to document each of these things, but if there's a discount because the provider is then going to be able to avoid needing to take collection efforts, that can be a reason that would support a discount. The prompt pay discount is offered to all patients without regard to their reason for admission, length of stay, or DRG. They're not advertised to solicit business, so don't want to advertise that you are giving these discounts. If you've notified private payers of your program, and then if the resulting discount, the cost of the discount that the provider then would bear is not passed on to the federal health care programs. And again, even if it complies with those OIG factors, consider Stark state laws and your private payer contracts. And this is the private payer issues, what I discussed a moment ago about that if you're taking discounts, it could ultimately impact your usual and customary charges. So definitely want to check your specific contracts and see, one, if they address discounts specifically, how they address usual and customary charges, and may be different per payer. So if you have a grid or a guideline for each of your payer contracts, I would definitely suggest adding discounts or limiting charges factors as a box or a line item in your summary of agreements. Providing free screenings or tests to patients is another service and benefit that sometimes providers will offer to patients. Similar concern that these are services that otherwise the patient would need to pay for, so they're being provided at less than fair market value, and potentially then that may induce, the concern is that could induce or may induce patients to receive items or services. If that were the case, could have potential violations of the federal laws we've talked about and state laws. The OIG has approved certain free screening services or tests when a few factors are met. Those are not conditioned on any items or services from any specific provider being used by the patient. The patient is not directed to a specific provider based on receiving the screening or test. The patient is not offered any special discounts or follow-up services as a condition of the free screening or test. And if the tests are abnormal, the patient is advised to see his or her own healthcare professional. So that was set forth in an OIG advisory opinion, and again, looking at the specific factors of a proposed arrangement, the OIG determined that those conditions would make for a relationship that was not likely to be abusive of the federal healthcare programs. Free transportation is also something that facilities will, primarily facilities will sometimes offer so that patients are able to get to the facility. Same concerns about that potentially being something the patients would otherwise have to pay for, so could be remuneration that may induce them to receive services, and related concerns about violating the federal and state laws. OIG has also looked at free transportation services, service arrangements, and consider those in both an advisory opinion and a bulletin about gifts to beneficiaries. So among the factors the OIG determined were in a compliant or at least likely to be non-abusive relationship arrangement were instances where the program was open to all eligible patients, not being selectively limited to certain populations. Type of transportation is reasonable. Travel would be to the local physician offices. Public transportation and parking is limited. That was a factor in the advisory opinion that the OIG looked at. And then additionally, that the cost of any transportation program provided would not be claimed on a cost report or shifted to a federal program. And like the other instances where you may be going through a checklist as you're considering any of these items, document, as much as you can where your program or your provision of a type of services are meeting these considerations that the OIG has looked at previously. Shifting slightly more to the provision of perks to providers or other referral sources, so not to patients. These types of gifts or perks could include a whole host of items, business opportunities, free items, discounted items, the whole universe of things that could be provided to providers or other referral sources. These are, potentially of concern similarly because they could be seen as remuneration that is being provided to induce referrals. And if so, could violate Anti-Kickback Statute, civil monetary penalties law. I think more likely in this realm, Stark law is going to very, very frequently be a consideration because it may be something offered to a physician. It is a lower risk due to that if the gift, the party receiving the gift does not refer anything that is a service or item payable by a federal health care program. In that instance, it's potential and likely that the federal laws won't apply, but one, you still may have your state laws definitely to consider, and there's no guarantee because the OIG has cautioned that carving out certain federal program business from certain transactions may not protect the parties if there are still other referrals for federal programs happening in different transactions, different times, unrelated to the gift or perk you're giving at the time, but there is that relationship where at some point federal program business is going between the parties. There are some anti-kickback safe harbors that cover certain gift and perk transactions. You definitely need to be mindful that they have to comply with all associated conditions. With each of the anti-kickback safe harbor conditions and components, to meet and get the protection of that safe harbor, you need to meet every specific condition. So if there are 4 items in a safe harbor, your relationship needs to have each of those components. 3 out of 4 won't give you the benefit of the safe harbor. It might be helpful in an argument later to try and convey why you had no intent and this was a compliant relationship, but will not give you the safe harbor of protection from prosecution under the Anti-Kickback Statute. And here's a list of some that tie to either discounts, subsidies, things like EHR, provision of EHR components, certain items offered to health centers. There's a host of safe harbors that may go to gifts or perks provided to providers or referral sources. Similarly, the Stark law contains safe harbors for certain transactions. Those are found in the Stark regulations, and again, want to meet each component of those exceptions. Professional courtesy, similar in potentially giving free or discounted items or services to a provider. The concern is that this could be viewed as remuneration and then may induce referrals for services. Stark law contains a specific safe harbor for courtesies, and that requires that there's formal medical staff, a written policy on professional courtesy approved in advance, that whatever is offered to all physicians, and it's not offered to government healthcare program beneficiaries unless they're showing a financial need. So again, if that's a practice that your organization plans to engage in, good to have your policy and your process set forth in writing up front, and then where you can document, follow that process or policy, and where you can document that you're following that process and policy. And we have just a few minutes left, so I'm just going to jump into some of the takeaways and compliance checkups that you can hopefully use in considering how these practices may play into your organization and what you can do to ensure you're compliantly implementing such practices. I'd suggest as a first step, you identify all of your remunerative relationships with referral sources. So maybe that is best achieved in a spreadsheet, a grid, something that really just goes through each of your contracts, where compensation is paid by your organization, whether that be for a lease, for marketing, for a variety of services. Call out, where each of your then compensation and remuneration relationships lie, and if those are with referral sources. And then review each of those relationships for compliance with the applicable statute or exception, to try and look at each relationship and see if there's any call out that there's no intent to induce referrals. Make sure that if it's something where you're looking to an anti-kickback, safe harbor, or Stark law exception, you have a written contract in place that is current, signed by the parties, and also complies with the applicable provisions of the exception or safe harbor you're trying to meet. Want to also confirm that then the parties are complying with the terms of that contract, that in practice they're not doing something else that, if ever audited or examined further, would show that there's an agreement but was not being followed. Want to look to fair market value and the compensation structure, so make sure that it isn't based on any volume or value of referrals, commercially reasonable. If you are able, and the method of doing this will depend on the size of your organization and type of organization, but implement some method to track and monitor relationships with referral sources. So have a central repository for contracts, something that tracks when contracts are up for termination or renewal, so you can ensure that you don't end up in a period where you're out of contract. Process for confirming compliance before payments or receipt of payments. And then, again, depending on how your organization may be set up in size, a process for review and approval of contracts, transactions, benefits or perks, and especially marketing or advertising. And involved in the process, these are among the roles and the types of individuals that should be involved in your compliance. And as you'll see, it's from administration all the way down to accounts payable folks, human resources, really anyone that may be involved in giving or having a consideration in something that is a discount, free service, waiver, any of the things we've talked about today, perks. And as with the other things, document that you've done such training so that you can show that you've trained your workforce if questioned or subject to an audit later. Here's a few additional OIG resources. The fraud website that the OIG maintains has a lot of good updates, and it's where they keep their central alerts, opinions, and advisory bulletins. As mentioned, going to send around several of the compliance items with the program slides, so you'll receive those shortly. And just one last note of caution on that. Do be aware, though, of just searching on the internet for, is X, Y, or Z relationship okay, or can I discount in this manner? Not only will you sometimes find information that's just not correct, often things change and will be out of date, so may not be the most current and still timely. We have a few Holland and Hart resources that you can also visit for additional health law resources and updates. And our next couple webinars are coming up next 2 Thursdays in August. I hope you can join us for accountable care organizations and social media use. Again, feel free to email or reach out directly if you have any questions, and thanks so much for joining us. Thanks. Bye.